Good morning. So we'd like to outline two concepts today with you. The first one is the advisability for all companies, including ones not based in Italy, that carry out activities having some sort of impact in Italy of implementing cross-border 231 models. The second one is considered that more and more countries are setting laws. I'm thinking Spain, recently with the Ley Organica #1 of 2015, Austria, UK for the Bribery Act, Mexico, or some minutes ago, Brazil, France for what concerns just some crimes like bribery. But more and more countries are setting laws that are linking the implementation of a compliance model to the exoneration of a criminal liability for legal entities. So it will be increasingly advisable that such compliance program, each implemented on the basis of individual national laws, are harmonized with a view to simplifying and finally creating supranational compliance programs. In order to understand the impact of the applicability of our Law 231 to foreign companies, and also, of course, to our national companies, we'd like to provide just some few information about its functioning in Italy. Our Law 231 indicates criminal liability for companies if the following conditions are applied. First condition, the offense has to be committed in the interest and or to the advantage of the company. Second condition, the offense has to be committed by a top-level manager or an employee or anyone representing the company. Third, the offense belongs to a list of predicate crimes as provided by Law 231. We have the list. We have a lot of crimes. Our law covers a lot of crimes. In this slide, we have just the most important category of crimes. Crimes against the public administration, so first of all, bribery. Crimes against public property, market abuse crimes, in general, all financial crimes, insider trading, etc. Corporate crimes. Recently, our parliament adopted the crime of corruption between in private sector, and this is a new corporate crime. Cyber crimes, the object of our conference today. Crimes against industry or trade, so violation of patents, license, etc. Environmental crimes, death or injury committed through the violation of workplace health and safety rules. So we have a lot of different crimes categories. And the consequence is that our model 231, the compliance model adopted under our law 231, should collect a lot of different protocols. Protocols to prevent financial crimes, protocols to prevent all these kind of crimes. So in the presence of such conditions, the company is exempted from criminal liability only when it had implemented before the perpetration of the crime a suitable and effective 231 organizational model that is a compliance program. The Ley Organica speaks about a compliance program. It's the same. It's the same thing. The 231 organizational model should provide crime risk prevention protocols in connection with the specific corporate activities. And then, second condition, the company has appointed a control committee, a supervisory board, we call it in Italy organismo di vigilanza, with the role of monitoring compliance between behaviors and the model and its effectiveness. And consider that the supervisory board should be totally independent from the board of the company. So it is very different from other typical functions of internal controls like compliance and internal audit. Should be composed by external professionals, and in this way it should be totally independent. This means that the implementation of the compliance program, I'm totally okay. This means that the implementation of a compliance program has an absolutely central priority role for the prevention of the risk of crime within companies, national and also foreign companies, exactly as it is happening today in other countries. again, in Spain, for example. Without a compliance program, the company is depriving itself of an instrument of prevention and control, and as a consequence, it has no possibility of being able to prove its innocence in case an offense is committed. The consequence of the application of Law 231 to a foreign company could be very serious. Our criminal judges apply financial fines from a minimum to a maximum of about 1.5 million, can apply bans, suspension of revocation of permits, ban on the operation of the business, prohibition from entering into agreements with the public administration, prohibition for advertising goods or service. In the Viareggio cases mentioned before, the criminal judge, the Viareggio,
German company.
See, the German company has been convicted to a fine of 400,000 euro and to the ban of the prohibition from advertising goods and services for 3 years in Italy, of course. Then the judge can apply the seizure of the profit. So more and more often, there is some problem with my hand. Okay. Criminal judges are applying Law 231 against foreign companies that have no offices or branches or subsidiaries in Italy. This is because it's enough for the offense to have partially occurred in Italy for the company to be convicted. In these cases, however, the foreign company will almost never be able to prove it implemented a 231 model. Since having no offices in Italy, it most probably considered implementing one as not necessary. This is our experience. So in the face of such cases and such risks, the solution is the implementation by foreign companies of cross-border 231 models applicable to their foreign seat in the country of origin, containing prevention protocols against the risk of offenses that may occur in Italy. Our firm has already designed cross-border compliance model with a supervisor board at the parent company's headquarters for several foreign companies, for international banks, for fashion companies, etc. In our research activities for cross-border models, we found ourselves with the need to coordinate the cross-border, and this is the point, and this is the point, to need to coordinate the cross-border model with the existing compliance program at the foreign companies' countries of origin. As a matter of fact, applicable policies in the country of origin could certainly have been considered suitable 231 protocols, and therefore there was no need to duplicate them, but it was necessary to extend their application from the country of origin to the Italian operations and submit them to the supervisory board's control. Of course, harmonization, okay. Let's continue without the slide, it's better. Of course, it's no problem. Harmonization activities will be all the more simple in cases in which the country of origin, think again of Spain, has implemented a law regulating criminal liability for legal person that is similar to the Italian one. Our Law 231 is very, very similar to your Lei Organica. To the point that in such cases, we may even imagine a single compliance program at group level, having a supranational applicability and being compatible with all internal jurisdiction. For example, to the Spanish Lei Organica, the Italian Law 231, the French Law Sapin, the etc., etc. And able to represent a single and centralized instrument for the prevention of the risk of crime in different countries. So, conclusions. It's clear how the regulation of corporate criminal liability is an example of export and internalization of internal criminal law. And this will add importance to harmonizing not only corporate liability laws, but also compliance programs at an international level. This important harmonization work will involve not only national lawmakers, but also companies who will be more and more interested in the implementation of a single cross-border compliance model that is compatible with individual national law systems, but is at the same time also applicable to cross-border activities. And professionals, of course, asked to draft such models. This is therefore a new, interesting challenge facing all of us in the interest of corporate compliance and legality. Thank you.